I come to AI and privacy, I think, from a very relevant standpoint, which is the human rights standpoint and background, and the background of a balance between public and private interests and protection of fundamental rights. So I was, for 15 years, the lead counsel with our national human rights institution, doing litigation cases on discrimination, employment equity, balancing of national security and human rights, online harms, so current topics that are becoming more and more relevant in the context of AI. And I'd like to mention these. As part of those cases, I did cases involving hate propaganda and had to have bodyguards accompanying me to trials and to conferences like this. So again, themes that we're seeing in this space, talking about how do we balance the safety of children online, the safety of individuals, but at the same time protecting fundamental rights. I spent some time in our global affairs department as a legal diplomat on international criminal tribunals. So the role of international institutions, international agreements, and the one-to-one relationships that are so important in making decisions on challenging issues is something I've experienced with. And I was, for 7 years, the top lawyer in our legislative branch in the Canadian House of Commons. So I have experience in managing privacy issues in that space, but also the parliamentary realities of lawmaking, which is also very relevant in Canada when we have a number of new bills, including one to modernize privacy, including one to modernize, to deal with AI with a specific piece of legislation. So when I was proposed as Privacy Commissioner in Canada, you have to be appointed by the government, but also confirmed by both houses of Parliament. So it gave me an opportunity to appear before those houses and tell them what my vision for privacy was, which I shared earlier this week, which was that privacy is a fundamental right and has to be treated as such, but also privacy supports the public interest and supports the private interest, supports innovation and Canada's competitiveness and overall strong economies, and that when we protect privacy, we generate trust in our citizens, trust in the institutions, the public institutions, but also in their participation in the digital economy. And I think these themes have resonated in the last 3 days in all of the discussions that we've been hearing in terms of leveraging data to achieve these hugely important public goals, such as health, private goals such as innovation and economy, but doing that while being visibly promoting and protecting privacy to support trust. In the context of AI, with my colleagues internationally at the DPA table, we've issued a number of statements and recommendations on AI. With the G7 DPA roundtable, we issued a statement on AI last year in Tokyo, setting out our strong message that while we are dealing with new laws for AI, we have current laws, and those current laws apply, whether they be privacy, whether they be competition, copyright, human rights. So it is not a legal vacuum. We may need to modernize things, but we have current laws. We're going to be applying them. I've launched an investigation on OpenAI with provincial partners that is ongoing. We've supported GPA resolution on AI and also a Canadian statement on our understanding of the principles for the responsible use of AI based on the legal principles in our law. And so I firmly believe that we can have innovation and competitiveness and technologies like AI while protecting fundamental rights. And I've said that while data is used to support innovation, we also need to have innovation protect data, including our personal information. It's interesting, we had a panel earlier this week on cross-regulatory collaboration, and I think that is one of the reasons why this work is so important, because AI in particular touches so many existing legal regimes, and we've heard discussions even this morning about competition and data protection and privacy and making sure that those regimes are not contradicting each other, that they're being coordinated. And the OECD did a report about a year or so ago about the digital ministers of the G7 countries, their views on the top benefits and the top risks of AI, and the top benefits were obviously the productivity gains and health and impact to solve challenges like climate change and so on. And on the top risks, there was risk to copyright, there was risks to privacy, there was disinformation, misinformation, and human rights violations. So we could see that these are the areas where there are existing laws that apply, and this is why this was our early message at the G7 and then at the GPA level, that we need to look at the laws that we have and we need to be applying them. We may need new laws, and I think where new laws perhaps may be changing things is more proactivity, modernization of concepts like anonymization, for instance, proactive obligations of transparency to explain automated decision making, and then opportunities to improve existing laws. I've made a number of recommendations to my Parliament on the proposed bill that we have to modernize privacy law and AI law, and including a strong claim that we need to have more obligations in terms of privacy impact assessments in the context of high-impact AI systems, and that this needs to be in support of transparency, and that the explainability needs to be there. Our current law, PIPEDA, the Personal Information Protection and Electronic Documents Act, has the key privacy principles that I think when we look at them, we can see a lot of them are very relevant and very helpful in dealing with AI, whether you're looking at accountability, identifying purposes, consent, limiting collection, limiting use, disclosure, and retention, accuracy, safeguards, openness, individual access, challenging compliance. I think these are all strong principles that can be challenged by AI, but can actually also serve to bring the responsible use and the trust in a situation where AI is being used. So again, there are other legal regimes such as human rights, and in Canada, a particular focus of the new bill that we have that's called AIDA or ADA would be to regulate AI in a proactive way, more specifically with respect to the outputs of AI, the uses and the impacts of AI. I think that the inputs of AI are going to continue to be regulated mostly by privacy legislation under my remit, but this bill would give our Minister of Industry responsibility over the outputs with a particular focus on biased outputs and what I would call non-privacy harms, which would be the material, physical, or economic. So really that focus on the risk, the human right risk of decision-making and impacts on vulnerable groups very much at the heart of that bill, and it's currently before our Parliament at committee, so we will learn in the next few months whether there's enough time for it to be concluded before our election, which is to be held no later than October 2025.